Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the dictation without any stop. We have heard the learned counsel appearing on behalf of the parties and examined the impugned orders of the High Court and also other materials on record. As noted herein earlier, the respondent had made an application before the Calcutta High Court under Section 14 of the Arbitration and Conciliation Act 1996 for a declaration that the mandate of the arbitrator Shri A. K. Gupta had already stood terminated. As had already been mentioned above, the appointing authority had appointed three arbitrators prior to the appointment of Shri Gupta, who were all unable to conduct the arbitral proceedings for some reason or the other. It may be kept on record that the respondent filed an application before the High Court for a declaration that the appointment of the arbitrator, namely Shri Amitav Basu, who was appointed as the sole arbitrator prior to the appointment of Shri A. K. Gupta, had stood terminated by an order dated 20th September 2004, by which the High Court had terminated the appointment and ordered the appointing authority of the appellant to appoint a new arbitrator who will conclude the proceeding and pass an award within 6 months from the date of his appointment. Subsequent to this order of the High Court, the appellant appointed Mr. A. K. Gupta as the new arbitrator who was to complete his proceedings by 27 March 2005, that is, 6 months from the date of his appointment. It is pertinent to mention that the appellant did not file any appeal against the above mentioned order of the High Court. Therefore, it may be taken that the appellant had accepted the aforesaid order of the High Court and thereby accepted its decision to fix the time of the arbitration proceedings to be mandatorily concluded within 6 months from the date of appointment of the arbitrator. The order thus having assumed finality, a time limit was imposed for the conclusion of the arbitration proceedings. Thus, the appellant is stopped from raising any objection against the imposition of the time limit as had been done by the High Court in this respect. From the records before us, we have noticed that, in spite of conducting a number of proceedings, the arbitrator was unable to conclude the proceedings within the time fixed by the High Court. The arbitration clause in the contract enables the arbitrator to extend the time for making and publishing the award by mutual consent of the parties. From a perusal of the documents before us, we notice that the parties mutually agreed to extend the time limit 31st August 2005 for making and publishing the award, which were further extended by the parties till 30th September 2005 on account of the arbitrator having failed to conclude the proceedings within the previous date fixed by the parties. But the arbitrator having failed to do so by 30th September 2005, the respondent moved the High Court to terminate the mandate of the arbitrator as he had failed to conclude the proceedings within the time limit fixed by the parties.